Welcome back to Just Liberty, my friends, where justice and liberty meet. I'm Alan Reinach, president of the Church State Council, and I'm here with my co-host, Bettina Krause, editor of the great magazine on religious liberty called Liberty Magazine. And we're here trying to take back religious liberty from the political extremes.
And talk about political extremes, Alan. The topic that we're talking about today is a case which really lays out two very starkly different understandings of how far the government should support religious activity. It's a case out of Oklahoma, and it involves a proposal to fund a Roman Catholic online charter school called St. Isidore. Now, Alan, what for you stands out about this case? What's interesting to you?
I don't know where to begin, but after decades of study of church state cases, I mean, the idea even that such a case would get to the Supreme Court, that it would even be, it would pass the laugh test that you could fund an overtly religious school. Um, the fact that a religious school would think it a good idea to have a charter school also makes no sense to me, but that's kind of irrelevant to the legal issues. Because the whole point of a religious school is that faith and community are intertwined, that faith and all is built through community. And really tough to build community online, as I think many of us and our churches have found out during the pandemic.
Yeah. Well, we're really lucky today to be able to talk to someone who has thought and written about this subject a great deal, Professor Frank Ravitch. He was in Japan when we first arranged this interview. He had to come home suddenly to the United States for a family tragedy. So we are delighted that he is still able to join us for this interview.
We are very happy to welcome back to Just Liberty Professor Frank Ravitch. Frank is an internationally renowned scholar of law and religion, also known for his work on Japanese law. He's the Walter H. Stowers Chair of Law and Religion at Michigan State University College of Law. He directs the Kyoto, Japan program, so he gets to take some students to Japan, but also a very staunch advocate for religious freedom. And Frank, we're delighted to have you for the interview today.
Yeah, I'm happy to be here, and I would like to just say I'm dedicating my participation today. My mother passed away on early on Sunday, and she's the reason I became so interested in religion and religious freedom, and ultimately law. And it led me to law and religion. So I want to dedicate my participation today to Arlene Ravitch, the most wonderful mother that anybody could ever hope to have. So
And we are absolutely honored to have that dedication for this episode. So thank you so much, Frank.
thank you, thank you. Basically, the stakes here. Look, one of the things we're going to talk about during the podcast is the fact that the U.S. Supreme Court since 2017 has expanded the concept of free exercise into places that we never really thought it would necessarily go, to the point where really in 2022 the court essentially held that if you have a funding program, in this case from Maine, because they couldn't have public schools in areas that were so remote that didn't have the students. If you have a program that gives funding to any private schools to allow children who don't have public schools to go, you have to include religious schools, right? But this case is even a big step further, because here we're dealing with charter schools, which under Oklahoma law, that's the state where this is all happening. Under Oklahoma laws, charter schools are expressly public schools. And in fact, if you look at the history of charter schools in the United States, If you look at the way they are structured in almost every state that has a charter school system, they are public schools. These are not private schools, and this was a big focus of the Oklahoma Supreme Court opinion and the Oklahoma Attorney General's argument that you can't have a religious charter school. And so this is the question in this case really comes down to, is the court going to expand this doctrine that's been expanded dramatically from 2017, where it was kind of a normal doctrine, to 2022, where it's basically mandatory funding, whether the court acknowledges that or not, for religious entities? Are they now going to expand that to public schools? I mean, in that case, in that 2022 case called Carson v. Macon, the court literally said, "Well, these are not public schools, so you're subject to the same funding requirements." But here, we're dealing with essentially what's a public school. St. Isidore is arguing it's really not, this is a contract issue, but, I mean, it's not. These are public schools. And so there's this is the question, is there anything left of the Establishment Clause in the funding context? Because the reality is the court, which complained that the Establishment Clause had supplanted the Free Exercise Clause, has now supplanted the Establishment Clause with its version of the Free Exercise Clause, um, and it's completely lost touch with the we'll talk a little bit about this play in the joints that the court had used for 40 or 50 years. Justice O'Connor was so eloquent. I'm writing about this, it's actually something I talk about in a book that I'm writing now. Justice O'Connor really eloquently, in her last, concurring opinion in a religion case, in the McCreary County case, she pointed out how the Establishment Clause, the concept of separation, and free exercise are part of the same idea, and that this play, she was essentially, without using the term play in the joints, referring to what justices from Rehnquist to Ginsburg had talked about as the play in the joints between the establishment and the free exercise clause. The idea that we can have a modicum of separation and free exercise. One doesn't have to eat the other. But the current court, it has used the free exercise clause, and if you'll excuse my old video game reference, as a Pac-Man, along with the free speech clause, and they have just eaten the Establishment Clause. And there was like a little piece of the Establishment Clause left in the funding context, which is public schools. You can't require a religious public school. Well, that's really what this case is about. Now, it is charter schools, but under Oklahoma law, charter schools are explicitly public schools under the Oklahoma Charter Schools Act. Literally, it says these are public schools.
So you've got
So
my head
that's, I know,
spinning with
a
thoughts.
long intro, but that's what this is.
You got me spinning with all kinds of thoughts. First of all, I've always been of the view that the two clauses were intended to complement each other, not to conflict. And that if you are coming to the conclusion that they're in conflict, your analysis is almost certainly flawed. Um,
Yeah.
but
Yeah, I think
thinking
that's true.
about, there's a long line of religion in public school cases, right? So going back to, uh, the 1950s and the early 1960s, that, the understanding that religion was not explicitly something that the government had authority over, and therefore, religion in public schools had to be voluntary rather than state sponsored. So the state couldn't, um, read the Bible over the loudspeaker or conduct a prayer over the loudspeaker, but students could pray and students could read the Bible and what have you. Um, it would seem that if we're going to allow funding of an overtly religious public school, then, by implication, we've completely abolished any barriers on religion in public schools.
Yeah, and interestingly enough, that is really what the Oklahoma Supreme Court says. And it's correct, right? Which is that while Oklahoma charter schools, are allowed to be versatile and adaptive in the way they go about their curricula, they are still public schools. And that under the Oklahoma Constitution, they also point out under the Establishment Clause, you cannot have a religious public school. That's a step too far, right? Oklahoma's probably not a state where the attorney general would argue that vouchers are a problem, and may not even disagree with Carson v. Macon, but they're saying that it violates the Oklahoma Constitution, it violates the Charter Schools Act in Oklahoma, and it violates the Establishment Clause of the United States Constitution to essentially have a religious charter school, which is a public school for the very reasons you mentioned, Alan, because they had in the contract with the St. Isidore School, they had to there's a model contract that was generally used for this was it's a virtual charter school. So there's this model contract that Oklahoma generally uses. They actually had to remove multiple clauses from that contract about being secular, which is required under the Oklahoma Constitution, about not having mandatory participation in religion. And all of that had to be removed because this is a religious school. There is no, I mean, St. Isidore's is honest about it. They're not claiming they're not a religious school, right? They're not trying, this isn't like a stealth case. This is this school is being honest. They're saying what they are. But the reality is that they are expressly religious. And you know, it's one thing if you're talking about a voucher. I think there are problems with government funded vouchers, but that's another podcast. But the reality is this isn't a situation like that. This is part of the public school system. Oklahoma has a constitutional provision that requires free public schools. They have a constitutional provision that does not allow taxpayer funding to promote religion. And bear in mind, this is for listeners that are familiar with this concept of baby Blaine amendments, these state constitutional amendments that were very heavily based in anti-Catholicism, and for that reason and others are likely unconstitutional. I think the court has, at this point, expressly said they're
So
unconstitutional.
this is the
Oklahoma's provision is not a baby Blaine.
okay, so these baby Blaines, I mean, these are from the 1800s, right? These are sort of
Exactly.
carryovers from a time in American society when anti-Catholicism was rampant and discrimination against Catholics was kind of, um, set in constitutional stone in some states. So you're saying that Oklahoma's provision prohibiting state funding of religious enterprises, that's not
It's
a
not a baby Blaine.
so how
In
do you
fact,
okay.
oh, I'm sorry, go ahead. No.
No, no, so how do you discern that?
So there's a few reasons why it's pretty straightforward. One, textually, it just doesn't look like a baby Blaine. So when you look at baby Blaines, right? As you said, most of them were passed in the latter part of the 19th century. They were heavily based in anti-Catholicism. I mean, the anti-Catholicism is one of the original American sins,
Right.
right? And so they are based in anti-Catholicism. And now there were people who backed them for other reasons, right? But they focused on education. They were targeted at Catholic schools, funding for education. They were based on the federal Blaine Amendment, which was proposed by Senator James Blaine. Well, actually, then Congressman James Blaine, but who became Senator James Blaine. But basically, it didn't pass the United States Congress, but it was targeting any public funding for religious schools, which everybody knew meant Catholic schools in that context. Um, the Oklahoma provision wasn't passed until later. It was many years in the early 20th century. It was reenacted later after that. There was no evidence of anti-Catholicism at the time that it was enacted, and the Oklahoma Supreme Court cites 3 or 4 prior Oklahoma Supreme Court decisions that had considered whether it was a baby Blaine, looking at its text, looking at its history, all of which agreed it is not a baby Blaine. And again, the first time I read I think it's, Article 2, Section 5 or Article 5, Section 2 of the Oklahoma Constitution. The first time I read it, I'm like, "This isn't a baby Blaine." Because, there are certain textual things when you see a baby Blaine that you kinda know, like, even because some were passed in the early 20th century, but there are certain things they have in common. And this is not limited to education, and the way it's worded, they're much more concerned about government, um, forcing it's more of a free exercise concern in the Oklahoma provision than an establishment one. The Oklahoma provision is much more concerned with the state promoting religion in a way that might interfere with people's freedom to practice their own religion. And so, given recent events in Oklahoma, we might think, "Really?" Like, the Oklahoma Attorney General saw it, and to his credit, Oklahoma is not a state that's known as a bastion of separation, but I think even, he saw this is not constitutionally permissible in Oklahoma, and, if we open this can of worms, we're gonna have a lot of concerns. And so
Well,
it
Frank,
was not a baby Blaine textually and historically.
just to be clear, the Oklahoma Supreme Court ruled against the Catholic charter school, right?
Yes, and the Oklahoma Attorney General was the one that brought the claim. I mean, this is not something those of us who do law and religion, usually when we're looking at something in Oklahoma, it is like what the head of their school board did, trying to impose school prayer, or when they tried to do the Ten Commandments monument and claimed it was a public forum. I mean, Oklahoma is not exactly a bastion of separationism. So when the Oklahoma Attorney General and the Oklahoma Supreme Court are so clear, and their arguments are really are legally impeccable. But I think from the St. Isidore perspective, this is a carpe diem moment. You have a court, as the title of my article for Liberty Magazine says, you have a court that seems to be based more in teleology, sort of what they want to do, than jurisprudence. And so, if you're going to push it, like if St. Isidore raised this same argument 10 years ago, I think everybody would have just laughed, right? I mean, nobody would have thought this was ever possible, even 10 years ago. Even really in 2017 when Trinity Lutheran was decided, everybody would be like, "No, you can't have a religious charter school." This would be a laughable argument. But it's the belief now is that there is a capture of the court. I believe in the book I'm working on now that it's actually a teleological court, which is something we really haven't had before. We've had conservative courts, progressive courts, courts in the middle, but we haven't really had a court that, as happened in Carson v. Macon, that just gets rid of its own tests that it just created 5 years earlier when it's inconvenient. Or that in Kennedy v. Bremerton, says, well, history and tradition, but then never applies it because Coach Kennedy probably would have lost under I've written about this, probably would have lost under history and tradition. Throughout most of US history, he would have been viewed as sacrilegious or a buffoon. And so, when we look at these things, um, I think, if I don't blame St. Isidore's counsel for trying to do this because you got a court that might go there. I actually don't necessarily think the court will go there in this case, because this may be a step too far. But this was a laughable argument 10 years ago.
So but since you talk about sort of the trajectory of the court, I want to summarize for our listeners without getting technical. Um, for a long time, after the court started to say the First Amendment applies to the states and there's a high and impregnable wall of separation between church and state, there were a series of cases that would challenge the no funding rule and would
Right.
carve out exceptions. So, I was at conferences way back in the 1980s, and Lee Boothby would be criticized for trying to make sense of the Establishment Clause cases, and the scholars were saying, well, there's no sense to be made of them. But I think the sense was, trying to find where there are reasonable exceptions to no government funding of religion. By 2000, um, things start to turn the other way. And in a series of cases, the court really starts to say, well, funding of religion is okay under some circumstances. But frankly, they went from the rule is no funding of religion, with some exceptions carved out. In the Lutheran Church case, they skipped over the premise that, well, you may fund religion. And they went right to, if you don't fund religion when you're funding a secular equivalent, that's discrimination. You must fund religion. And they doubled down on that in the main case in Carson, as you said, that if you're going to fund kids to go to private school, high school, when there's no public school available, you have to fund the religious school. But this case now takes us in a completely, beyond the discrimination model, because this is not, discrimination. This is simply funding religion. You can open the floodgates, and there are virtually no restrictions.
Yeah, and when you look at if you think about what you were just describing as kind of like a set of waves, right? So the first wave was the kind of the no funding, strict separation wave. And then we got into this wave, probably one of the big cases you mentioned, the early 2000s. You had a plurality opinion in a case called Mitchell v. Helms, followed by this case, Zellman v. Simmons Harris, that said it's actually okay to have school vouchers, as long as there's parental choice and so forth. And so that was now a wave where, okay, it's okay to fund government, but the understanding was you probably don't have to, because shortly after that, there was this case called Locke v. Davy, which was limited, but said, well, the state of Oregon doesn't have to fund somebody to become a clergy member. So there was, whether that meant you didn't have to wasn't clear, but it suggested that. And then we now got to this wave with the what I always refer to the post 2020 Roberts Court, because Trinity Lutheran, that 2017 case, opened the door, but it was still very limited. It was this case Espinoza in 2020, and then Carson v. Macon in 2022, where the court now went from the first wave, you can't really fund religion with a few exceptions, to the second wave, which is government, you can, but you can't do it in a way that favors religion over irreligion, but you can include religion in your menu. To the 2022 cases, which is, no, if you have anything else on your menu, your private funding menu, you must have religion on that menu if someone wants religion on that menu. So your menu, which can have any private course on it at all, even a theoretical private course, now has to have religion as part of it. And then, yeah, this would be now breaking down the barrier between public and private, because all of those cases, from the first wave to the last wave, never suggested that government would have to fund a religious public school. The debates was always over funding for government funding for private schools, but never about government funded public schools. Now, St. Isidore's is arguing this isn't about public or private schools. This is about a contract between us, and excluding us from this contract is discrimination under Carson v. Macon. I mean, I look, I respect lawyers doing a good job of lawyering, and I see where they're coming from, but that's nonsense. I mean, it's just complete nonsense. Um, I don't think these lawyers would have made that same argument with a straight face 10 years ago. If they didn't have the court they have now, I don't think this argument would be made. And it's not bad lawyering on their part, right? I mean, they've got a court that they think will do potentially what they want. So what was ludicrous a few years ago, we see across a number of areas with the current United States Supreme Court. It was what was unthinkable
Right.
is
Alright, but
now the
let's
norm,
but
you
let's
know?
cut to the chase, because we've had a wonderful discussion about kind of the law and where we've gotten to. Talk to our listeners about, why is this a bad thing? From a gut level, if you're a parent and you wanna send your kids to a Catholic school, you know, is this a bad thing to have the Catholic school funded by the state? If you're not a Catholic and your kids are in public school, is it any skin off your, neck if the state also funds the Catholic school? Why, from a social standpoint, practical standpoint, is this a bad thing in your view?
Maybe what are the knock-on effects of a decision to open up floodgates of funding for this?
Yeah, and this is a hard one because I do think that argument is better in the context of, say, vouchers or tax breaks, right? That parents who are paying tax dollars to send their children, they still have to pay their taxes for their public schools, but then they have to pay out of their own pockets to send their children to religious schools. So if they're about that argument, I think works okay for those. I think there are other problems. I think for religious
I
minorities,
I
voucher
pay
programs are an
taxes for
issue.
public schools, and I don't have kids in school. My kids are long gone.
Right.
So, I don't like that argument very much.
Well, no, but that's the argument that's been made for
Right.
vouchers and for, I mean, in a way, I'm playing the devil's advocate there, but that is the argument that's been made. I don't think that argument works here. And the reason for that is, once you start turning public entities as a as opposed to public funding for a variety of private entities in the marketplace of ideas or whatever, but now you're talking about public entities. You're dealing with a battle over the pie. There's a limited amount of money for education. And divisiveness is something that it already exists, right? There are people in Oklahoma who may have real concerns about Catholic schools, or people who have real concerns about, a left wing school or a right wing school, or, religiously. Because of all the anti-Muslim laws in Oklahoma, there are going to be people who are going to have problems with, a Muslim school, probably with Jewish schools, Buddhist schools. But the reality is that once you open that pie up, there's going to be fighting over it. And that fighting is going to be along religious lines. It's something Justice Breyer has warned about for years, and he had taken up the mantle of earlier justices, going back to Justice Jackson and Justice Rutledge, and so second Justice Rutledge, but basically, he the concern is, once we start fighting over the public pie for public, not, I think this argument, quite honestly, works very well for vouchers too. It's one of the reasons I am not personally a supporter of vouchers. But we end up fighting over the pie. The second factor is religious minorities, right? Most religious minorities do not have enough money or capital in many places to have charter schools. Um, the reality is, in while this case is about a virtual charter school, which theoretically could allow religious minorities to have charter schools from other states maybe available. Most of the charter school systems in the US are primarily brick and mortar. And so if the court goes this way, you're going to have a system where essentially Christian charter schools are supported in communities where religious minorities have a large enough population. Maybe in those communities, you might get charter schools from other religions. But even among Christians, there are going to be places where denominations don't have enough people, so they don't have a charter school, and others do. And then maybe people leave the public schools for that charter school, or they leave secular charter schools for that charter school, and it ends up having a negative impact on the money left for public education in general and non-religious charter schools. Um, but these are all policy concerns. I mean, I do think that in the end, almost everything SCOTUS has done since 2020 harms religious minorities. Ironically, even the free exercise cases, because it's expanded free exercise in a way that is likely to be harmful to religious minorities. Vouchers are not good for religious minorities. They just aren't. The reality is that vouchers tend to drain money from public schools. They tend to inure to the benefit of highly subsidized religious schools, which religious minorities rarely have. Um, and, um, that's one of the reasons I've long opposed vouchers, but this isn't even vouchers. We're not even talking about vouchers here. We're talking about fully state-funded religious schools. And that is, that takes the voucher concerns that I have about religious minorities and about the battle over the pie. Justice Breyer, Justice Souter, Justice Stevens in the Zelman case, in their dissents, all pointed this out about the battle over the pie. But the reality is that that you start having religious you start having religious charter schools. It's the same problem on steroids. So I mean, I don't want to be like I like to be a positive person, you know, but this is if the court goes now, I'm not convinced the court will go that way. But excuse me, if the court does go that way, it will be it will be it will be bad for first of all, I think it will be bad for American education as a whole, not because there's anything wrong with religious schools, but because it's going to break down what's left of uh, you know, um, secular fund secular funding models where religion doesn't really enter as much into the curriculum, but there may be systems like vouchers and so forth to fund people who go to private schools. Um, but it's also just going to be the final nail in any concept of separation. And also, by the way, federalism. This court, which people call conservative, I don't view this court as conservative. They do not they only follow federalism when it gets them where they want to go. In Carson v. Macon, they ignored Maine's situation. They ignored Maine's situation wasn't a baby Blaine either, right? They ignored Maine's claim. Same thing with Montana Department of Revenue and Espinoza. They ignored Montana's federalism, and they claim some concurring justices claimed Montana's provision was a baby Blaine, but it wasn't. It had been repassed in 1974 for different reasons. And we've seen it repeatedly in in religion cases with this court. Federalism is gone. If they rule against Oklahoma here, where there are adequate independent state grounds, there was really no reason to even hear this case. And if they hold against Oklahoma here, then they don't believe in federalism. I mean, after Carson v. Macon, it's hard to believe they believe in convenience and teleology. I mean, I'm sad. I mean, I've disagreed Zellman. We've talked about the Zellman decision. I was a horrible critic of the Zellman decision, the voucher decision. I never lost faith in the Rehnquist court. I didn't agree with them on a lot of things, but that's the way it goes. That's just the game of law, right? You can disagree, you can agree, things change, things move. But with the current court, if they hold in Oklahoma's favor here, it's just pure teleology. There's no basis for it all. For those who, I mean, I have a little bit of a background in philosophy, but teleology is just you have a goal and you want to get there. You work your way back, right? Courts do that sometimes anyway, but this is another level of it. I'm not convinced they're going to do it. I'm one of the few people who still has some hope that maybe what they're going to do with this case is
Draw some
say
boundaries.
that's a boundary too far. You
Well, and that's
Public schools are too far.
and this is a big takeaway from me from our conversation. Number one, it is surreal that we are having this conversation, and number two, we're going to have part two of the conversation after the court rules.
Yes.
So,
Yes.
Frank, thank you so much for giving us your insights and, I mean, just sharing with us the incredible background that has brought us to this point where we're sort of teetering on the edge of a new era of establishment clause jurisprudence.
It's my pleasure, and it's always great to see both of you. I think you do great work, and it's important to keep people aware of these things. There's so much going on, and, sometimes we lose track of things that will have a great impact on generations, and this is one of those things.
Yeah, couldn't agree more. So, Alan, that was sort of a mind bending exercise to sort of consider that we have come to this point in Establishment Clause jurisprudence when we may be on the cusp of the Supreme Court sanctioning a wholly funded, state funded religious school. I never thought those words would come out of my mouth, but there you are. I guess we really have to just wait and see.
Well, we don't have long to wait. By the time the show is posted, it should be only a matter of weeks.
Yeah. Okay. Well, then, until next time, until we have an update on this case, I'm Bettina Kraus with Alan Reinach. And remember, eternal vigilance is a price of liberty.